So how do you protect yourself from a whistleblower lawsuit? I'm the business guy. I'm the CEO of Lawyers Limited and Asset Protection Planners, the nation's largest asset protection firm. So what is a whistleblower? A whistleblower is a person who exposes a private or public organization's confidential information or activity that is considered illegal, unethical, or incorrect. Whistleblowers report organizations that break the law, engage in fraud or corruption, or pose a threat to public interest or national safety, but also violations of company rules and policies as stated in legal documents such as corporate bylaws or LLC regulations may constitute grounds for whistleblower allegations. Laws are in place to protect whistleblowers from facing legal, criminal, or social repercussions regardless of whistleblowing classifications as public or private. How to protect your business from a whistleblower. Companies cannot use any clause, term, or provision that prohibits whistleblowers from reporting any illegal, unethical, or incorrect information, practices, or activities. Confidentiality agreements do not trump a whistleblower's rights. The best way to protect your company from a whistleblower is to be aware of and follow constitutional, criminal, and employment laws, among others, that pertain to your business and legal jurisdiction. Certain industries have more potential risk for whistleblower claims than others: healthcare businesses, nonprofits, and government contractors. A proactive method of protecting yourself against whistleblowing is to implement a complaint policy that outlines how matters will be handled. Make it easy for them, even incentivize transparency laws for them to come forward about their concerns with you instead of a third party. Here's an example. Novartis Pharmaceutical Corporation faced an allegation that between 2002 and 2011, they violated the Anti-Kickback Statute and False Claims Act by providing doctors with cash payments, luxury travel, and meals to induce them to prescribe Novartis cardiovascular and diabetes drugs reimbursed by federal healthcare programs. The total settlement? $642 million. A Florida-based pain clinic and two former executives faced an allegation that they automatically ordered urine drug tests for all patients at every visit, regardless of need. Total settlement, $41 million. So to protect yourself against the financial damages of a whistleblower lawsuit and the strongest asset protection to keep just about any civil lawsuit from taking your assets away is to set up an international asset protection trust. Domestic trusts simply don't work because we have seen results-oriented judges repeatedly blow right through them, since the trust and the trustee is under the jurisdiction of your local courts. The strongest of these trusts include the Cook Islands Trust, the Cook Islands are south of Hawaii, and the Nevis Trust in the Caribbean. Our organization has set up more Cook Islands trusts than anyone in the world. Domestic courts do not have jurisdiction over our law firm that serves as trustee in these countries. Plus, these two regions do not recognize foreign judgments that might attempt to reach the trust funds. We place an international LLC inside of the trust and make our clients the initial LLC manager and signatory on the bank account. Should someone threaten the assets, our offshore law firm can step in as LLC manager to protect you. Now, speaking to employees now, unless lives are at stake, talk to your boss and keep going up the chain until your employer takes the proper action. In most cases, it is best not to risk animosity at work by tattling on your boss. They may not be able to punish you, but it's not fun to work in a place where many of the people hate you or simply tolerate you because they have to. So give your boss a chance to correct the problem first. Bring the problem to their attention. If they don't take action in a reasonable time, then and only then, except for in extreme cases, blow the whistle. Okay, so let's go into more detail about whistleblower regulations. OSHA's Whistleblower Protection Program enforces the whistleblower provision of more than 20 whistleblower statutes protecting employees from retaliation for reporting violations of various workplace, safety, health, airline, commercial motor carrier, consumer product, environmental, financial reform, food safety, health insurance reform, motor vehicle safety, nuclear, pipeline, public transportation agency, railroad, maritime, securities tax, antitrust, and anti-money laundering laws for engaging in other related protected activities. Okay, let's talk about protection from workplace retaliation. An employer cannot take an adverse action against an employee, such as firing or laying off, demoting, denying overtime or promotion, or reducing pay or hours for engaging in activities protected by OSHA's whistleblower laws. Retaliation. The whistleblower laws that OSHA enforces prohibit employers from retaliating against employees for engaging activities protected under the laws. So what is retaliation? Retaliation occurs when an employer, through a manager or supervisor or administrator, fires an employee or takes any other type of adverse action against an employee for engaging in a protected activity. What is an adverse action? Any adverse action is an action which would dissuade a reasonable employee from raising a concern about a possible violation or engaging in any other related protected activity. Retaliation harms individual employees and can have a negative impact on overall employee morale. Because an adverse action can be subtle, such as excluding employees from important meetings, it may not always be easy to recognize. Adverse actions may include actions such as firing or laying off, demoting, denying overtime or promotion, disciplining, denying benefits, failing to hire or rehire, intimidation or harassment, making threats, reassigning to a less desirable position, or actions affecting prospects for promotion, such as excluding an employee from training or meetings, reducing or changing pay or hours. More subtle actions such as isolating, ostracizing, mocking, or falsely accusing the employee of poor performance. Blacklisting, intentionally interfering with an employee's ability to obtain future employment. Constructive discharge, that is quitting when an employer makes working conditions intolerable due to the employee's protected activity. Reporting or threatening to report an employee to the police or immigration authorities. Okay, so are temporary workers protected from retaliation? When a staffing agency supplies temporary workers to a business, both the staffing agency and the client, commonly referred to as the host employer, may be held legally responsible for retaliating against workers. What is an example of retaliation? Here's an example situation. A worker informed her employer that she called OSHA because she believed there was a fire hazard that her employer had refused to fix. A workplace practice existed which allowed all employees to swap shifts if they intended to take time off. The worker tried to swap shifts a few days after she told her employer that she called OSHA, but her employer did not allow her to swap. However, the other employees were still allowed to swap shifts. Now here's the example analysis. Workers have a right to call OSHA to report an unsafe condition. Section 11C of the Occupational Safety and Health Act protects workers who file complaints with OSHA. By calling OSHA to complain about the fire hazard, the worker engaged in a protected activity under one of the whistleblower laws administered by OSHA. She informed her employee that she called OSHA, and her employer denied her shift swap by only a few days after being notified that she called OSHA. In addition, she was the only employee denied the ability to swap shifts. The denial of the shift swap is an adverse action, and in this case, it appears that her employer denied her shift swap because she engaged in the protected activity. If the employer denied her request to swap because she called OSHA, then retaliation has occurred and the employer's actions violated Section 11C of the Occupational Safety Health Act. Accidents happen and people make mistakes. So number one, create an environment where people feel the right to air their grievances. Number two, if you have accidentally committed a whistleblower violation, we assume you did it because of your lack of knowledge of the laws. Now, none of this is legal advice, by the way. See an attorney for that. But there are ways to protect your finances from whistleblower lawsuits and other lawsuits that threaten your finances. Give us a call at 1-954-400-1050 or fill out a free consultation form at assetprotectionplanners.com. Thanks for watching. See you next time. This is The Business Guy.